Welcome back to Winning Isn't Easy. Can you sue your employer if they're interfered with your rights to claim disability benefits? Under ERISA Section 510, it's unlawful for an employer to retaliate against an employee for exercising their rights under an ERISA plan or policy and interfering with the employee's receipt of benefits. And obviously, that can be an issue both in group health claims and also an issue for disability benefits. So what happens if you're injured while driving your tractor trailer for your employer and you file a claim for your disability benefits? And it's denied on the basis that text messages you send about the accident and potential injuries fail to satisfy the plan requirement that the claim benefit be submitted in writing. Really? Well, can you sue your employer for retaliation or interference with protected rights? And what do you have to prove in a Section 510 claim? Now, remember, in a Section 510 claim, you have to make a prima facie showing of a prohibited or adverse employer action, i.e. the termination. Action taken for the purposes of interfering with the attainment of your disability benefits and any right to which you were entitled to those benefits. So once you've done that, once you've established the basis of the 510 claim, then the burden of proof is going to shift to the employer to establish a non-discriminatory reason or an explanation for its actions. Now, if the employer can establish a non-discriminatory explanation, then the burden is going to shift back to you to show that whatever the employer's explanation is, that it was a pretext and the real purpose was the denial of benefits. We've talked about this pretextual denial process before, and it sounds like a ping pong match, right? To commit a prohibited or adverse action, the employer has to discharge, fine, suspend, expel, discipline, or discriminate against a participant or beneficiaries. That's the key. That's the analysis that we're always looking at. So how does an ERISA Section 510 retaliation or interference claim with protected rights work in the real world as it relates to disability benefits? Now, I started this segment by talking about the story of Miss Cervantes, and she was a truck driver who delivered auto parts. Her employer offered her an insurance plan covered under the ERISA statute, and the plan required that when an employee or participant was involved in an accidental injury, that they had to do several things. They had to immediately report it in writing to their supervisor, and the failure to do so could subject the participant to a disciplinary action, including termination and a denial of benefits. So there were some significant consequences. The term immediately was defined to mean no later than 24 hours after the end of the shift during which the occurrence took place, the injury or the accident. So she was involved in a collision resulting in a personal injury and a property damage claim. And within hours following the incident, she called her supervisor to report the incident, and she was instructed to undergo a drug test. She communicated via text message in writing to her supervisor and the owner of the company. She met with her supervisor at a drug testing facility near El Paso and completed the drug testing that was required. She texted her employer, providing the phone number and the name of the officer who responded at the scene of the accident. And she also sent photos of the text messages discussing the accident to them and provided photographs to her employer. So there's a lot of communication here. 11 days after the accident, she met with a supervisor to discuss the accident. And at that time, and only at that time, was she given an employee report of injury to complete. Now, she refused to sign it because it contained, as it often does, inaccurate and incomplete information about the incident. And ultimately, of course, her claim was denied on the basis that the medical providers were not authorized and she hadn't timely reported the accident pursuant to the terms of the plan. Now, you got to really wonder about that, don't you? She appealed, and the appeal was denied, and the case ends up in federal court. So what does the court do? The court said, look, Ms. Cervantes had provided evidence that could lead to a conclusion that her employer interfered with her ability to meet the plan requirements. And that was because they prevented her from accurately completing the required form and then basing the benefit denial in part on the fact that she didn't sign the form. Now, the court also found that her text messages could meet the requirements of the plan and that the employer's denial of the claim, could have been motivated by their desire to interfere with her rights to get medical treatment and, of course, to collect disability benefits. The court denied the employer's motion for summary judgment, and let's hope that she gets her disability benefits and her medical benefits in the next round. You can see that facts matter, and each particular situation is different. So the law provides the framework for the analysis for these types of 510 retaliation claims. And then you have to go through the laundry list of facts, as we've discussed in the second segment of this podcast. And then you've got to apply the law and the facts to the case. And you can see in both of the stories I told you about the results of these particular cases. So I hope that you have enjoyed this week's episode of Winning Isn't Easy. Like our page, please. Please leave a review and please share it with your friends and family. Please subscribe to this. I think this is a great educational podcast that will help you learn more about ERISA disability and medical benefits. And you're going to be notified every time that a new episode comes out. Tune in, please, for our next episode of Winning Isn't Easy. Talk to you later.